Hello everyone, welcome to the 10th and the last session of the subject Procurement and Contract Law. In this session, we will be continuing what we have been discussing on contracts in the previous session. During this session, we will be focusing on few key aspects, and they will be: what are the contents of a contract? What are the important clauses of a contract? What are the defects that you find in a contract? How can you terminate a contract? And lastly, how can you apply remedies to a contract? So let's explore. The first area that we will be focusing will be what are the contents of a contract. In the next few slides, we will be discussing this in detail. So when you discuss about the contents of a contract, the most important content would be the terms which are included in a contract. The entire contract is made up with terms which are offered by one party and accepted by the other. There are certain terms which are expressed, meaning that will be fixed and agreed within a contract. Also, there might be other sort of terms which are called as implied terms, meaning the parties may be bound by these terms which they have not expressly agreed. Some of the terms are very crucial and important to the existence of the contract, which are called the conditions. And there are few other terms which are more trivial, such as warranties, and different remedies are available for each of these terms breach. Even if a party is in breach of a contract, they may be protected from liability by an exemption clause designed to exclude or limit the liability. So when you talk about terms, as I stated before, there are two sets of terms that can be identified in a contract. The first set of terms are called the express terms, which are specifically communicated by the offerer and then agreed and stated in the contract. Then we have the implied terms, which are such as statute, custom, and codes. So these implied terms are the terms where the parties are bound by but not expressly agreed within the contract discussion. So what do you mean by statute? Statute is a written law passed by a legislative body of that respective country. So when discussing from a contract point of view, these will be the laws that has been written and passed by the legal framework of the country. Let's discuss few of these laws. One example would be the Sale of Goods Act safeguards consumers by implying terms concerning the standard and the quality of the goods in most sale of goods contracts. The seller will be in breach if the goods do not meet these standards, regardless of whether the seller gave any express undertaking to the buyer or not. So, within this context, let's look at some implied terms. The following are some examples of implied conditions that you see in major contracts. The seller has lawful authority to transfer ownership of the goods. Goods will match their description. Goods will be on satisfactory quality. Goods will be suitable for any purpose specified by the buyer. Goods will match any sample shown to the buyer prior to the contract being made. So these examples, what we just discussed, will not be specifically mentioned in a contract or agreed on a contract, but they are implied and these conditions are bound. The following set of terms are implied in all contracts involving the supply of a service. And they will be: work will be performed with all reasonable care and skill. Work will be carried out within a reasonable time. Price charged will be reasonable. So what we need to understand is the above are specified as implied terms only, not as conditions or warranties. And therefore, the amount of damage caused by the breach will be used only as an evidence of their importance. Also, we need to make sure and understand that a payment can only be refused if the breach amounts to one of the conditions only, not for implied terms. So the second point under implied terms would be custom. What do you mean by custom? If you put in a very simple way, it could be the practice, how things have been done. So in many trades, it is customary for certain practices to prevail in performance of a contract. Example, in crane and plant hiring contracts, it is generally implied that any damage to the equipment during the hiring period will be the financial responsibility of the hirer and not the owner. So for each and every transaction based on their industry, there will be a standard practice, which will be a sort of an implied term. Then, when we move on to the last point under implied terms will be codes, meaning how the local codes will look into implied terms from a business efficacy point of view. The codes are not generally sympathetic to parties who assume they have rights under a contract which were not expressly agreed. Also, exceptionally, the court may imply a term to give business efficacy to the contract if it lacks a term so obvious that the parties are deemed to have intended to include them. So, under implied terms, we learned three main points, and they are statute, custom, and codes. The terms which are included in a contract are the most important content of the whole contract. And that's why when two parties enter into an engagement, both parties spend some considerable time on discussing and agreeing on these terms. So any classification of these terms will be determined by both parties to make sure that both parties have sort of a safeguard within the contract period. Any trivial matter may become an important factor and it will be discussed before an acceptance takes place. So as project managers, it is very important that when drafting a contract to go through all the points and the terms in detail and make sure that all stakeholders understand the terms very clearly so that when the operation starts, there will be no confusions. Through my experience, I can say when legal people, the lawyers, when they draft these contracts, sometimes there could be legal wordings that may go into a contract and a layman might not understand them. So the project managers needs to ensure that there will be a briefing session or an awareness session sort of a thing where all the stakeholders who are not lawyers understands the terms which will be in a contract. Moving on, another important part of a contract, which are called conditions. A condition is a major term of a contract and it goes to the root of the contract. Any breach of a condition entitles the injured party to terminate the contract and claim damages, or they can continue with the contract and claim damages. So, these conditions are an important factor of a contract, and definitely both parties need to agree on these conditions before they are drafted and finalized in a contract. From conditions, now we will be moving into warranties. A warranty is a minor term in a contract. They are ancillary to the main contract, meaning supportive terms rather than crucial ones. Any breach of a warranty will only entitle the injured party for damages and not to terminate the contract. Now that we have discussed conditions and warranties, we will be moving into another area which is called innominate terms. As per the English law, innominate terms are those that are worded very broadly to cover a variety of breaches. Some could be serious and some are not. It is left to the court to decide whether a breach will be a major or a minor within these terms. So we need to understand that not all terms are identifiable as conditions or warranties. The use of the words condition and warranty and therefore not conclusive and are used as evidence only.